seated.
State of Wisconsin versus Jason Lindman, 22 CF 766 and 23 FL 1513.
Please state your addresses.
Good afternoon, Your Honor. Assistant Attorneys General Emily Thompson and Tara Jens will appear for the state of Wisconsin.
Jason Lindman appears in person. Counsel Scott Seaman, good afternoon, Your Honor.
Is the state in compliance with victim rights?
Yes, Your Honor, we are.
It appears that several victims are here today. We are scheduled today for the sentencing hearing on this matter. Before we get started with that, there are a few housekeeping matters that I did want to address. The first one is the citation 23 FO 1513 has been tracking this case. Is that a matter that we need to schedule a separate date for, or what are the parties' intentions with that citation?
Your Honor, we move to dismiss that citation at this time. In light of the trial verdict and in light of the fact that the forfeiture involves a fair amount of circumstantial evidence, we don't believe that the public will be harmed by dismissal of this boat OWI first forfeiture, and so we're asking for the court to dismiss it at this time as part of the sentencing.
And I presume that the defense is in favor of such a dismissal?
No objection, Your Honor.
Given the evidence that came out at trial, I do believe that the state would have a difficulty meeting its beyond a reasonable doubt burden as to that citation. The public will not be at harm by that being dismissed, so motion granted.
Your Honor, just to clarify, the burden that the trial would not have been beyond reasonable doubt, but we do move for dismissal of the same.
Okay, thank you. As to the other matter for housekeeping, I did see that there was a request for restitution. Is the defense contesting that restitution request?
We are, Your Honor, at this time. I contacted the court and the state by email. Friday morning, I received by e-file approximately 80 pages of restitution information requesting almost $600,000. There's a significant amount of information there to be gone through, as well as the restitution amount. So at this point, I think from correspondences with the state and the court, I think the parties are all in agreement that we need to have an adjourned restitution hearing set.
And then we will schedule a restitution hearing date. And I think there were some dates that were potentially circulated. Do we have one of those dates available?
January 22nd at 1.
Does that date and time work for the state?
Your Honor, we did discuss that with the clerk prior to going on the record today. We agreed that that date and time would absolutely work for us for a restitution hearing. And I would like to note that it was always our understanding among the parties that there would need to be a restitution hearing in this matter because the restitution is naturally quite large. The request is quite large. And so we were also hoping that perhaps the attorneys involved in the civil suit would be able to take this additional time to resolve those matters to streamline the restitution process in the criminal case.
Okay. January 22nd, does that date also work for the defense?
Yes, sir.
Is there any victim that does not work for?
Your Honor, I will also note that we have not run that date and time, although it works for the two of us sitting at this table, we haven't run that date and time past all the victims who are requesting restitution or their attorneys, and so there may be some amendment to that date as we move forward.
And if we need to handle it with some of the victims going on the 22nd and others going a different day, we can discuss it at that time. But we'll leave that date on for now, that January 22nd date. So those were some of the housekeeping items that I wanted to address before we get into the sentencing aspect of this. So how this will be handled is the state will be given the first opportunity to speak regarding its recommendation as to the sentencing. After that, the victims will be offered an opportunity to speak should they choose to do so. I will just identify you as victim number on the victim number key. If that is how you prefer to be identified, just stay where you are and speak in the back. The bailiff will provide you with a microphone. If you do wish to come forward and speak from the witness stand, that is your option to do so. But if you do, then you will potentially and likely be on the camera feed, which is being live fed here. So if you wish to not have your face on the camera, but just speak, you can do so from the gallery. But it is your option if you want to come forward as well. After the victims have been given an opportunity to speak, then the defense will be given its opportunity for the final word. So with that, the state may begin.
Thank you, Your Honor. I'm referring to the second amended information that was filed on June 5th, 2024, which were the charges that were covered at the trial. So on count one of the information, which alleges second-degree reckless endangering safety, upon which the defendant was found guilty, we do recommend that the defendant withhold sentence and place the defendant on probation for a period of 6 years. Although we will note for the record that we will not object to early termination after 4 years if conditions of probation are met and the full amount of restitution is paid. We would ask the court to impose the following conditions of probation on count one, that beginning with 9 months of conditional jail time with Huber, that he neither use nor possess any alcohol, controlled substances, or paraphernalia without a valid prescription, that he complete an AODA assessment and treatment as recommended, that the defendant be required to complete a boating safety course, which is to be approved by the agent, that he not have any contact with the victims unless contact is initiated by the victim and approved by the agent, that he pay restitution in an amount to be determined, that he complete and follow through with any other conditions as designated by the agent, that he provide a DNA sample as required by law, and pay court costs on all counts. On count two, which alleges second-degree reckless endangering safety, upon which the defendant was found guilty, we are requesting the same disposition to run concurrently with that in count one. On counts 3 through 6 and 8 through 14, all of which allege boat hit and run causing injury. I will note for the record, we're not requesting a sentence on count 7 because, of course, the defendant was found not guilty of that single count of trial. We are requesting a sentence of 6 months jail on each count to run concurrently with each other and with the conditional jail time in count 1. And as to count 15 of the information, which alleges negligent operation of boat, we're recommending a sentence of 6 months jail to run concurrent to all other counts. As Your Honor is aware, of course, the court is required to take into account numerous factors at sentencing, most prominent among them being what are known as the galleon factors, the seriousness of the offense, the character of the offender, and protection of the public. So I'll begin with seriousness of the offense. And I'll note that I'm not going to go through the facts of these crimes to this court. Your Honor knows it as well as anybody at this point. But what I do want to talk about is the victims. Now, at the time of the crash, there were 6 other people on the defendant's boat. He was responsible for their safety as the driver, and it was up to him to decide where and how to operate the boat. At the same time, there were 44 people on the Loose cruise boat. They were out having a good time on the biggest, slowest boat on the Fox River at that time. And the defendant's poor driving and bad choices made throughout the day turned their fun night into a tragedy. Multiple people were injured in this crash. Prior to trial, 12 people provided the state with their medical records so that we could issue charges alleging injury. And when those people testified, They didn't seem to exaggerate their injuries, and in fact, some of them seemed to downplay their injuries. And of course, we cannot look at all of the people on the loose as if they were a single person. Everybody had a different experience. Everyone had a different vantage point. Everyone has different life to live afterwards and different effect of this crash on that life. Now, beyond those 12 people who provided us with their medical records, many others reported actually suffering injuries, yet their injuries were not represented in the criminal charges. Yet, of course, they are still victims of the second-degree recklessly endangering safety charges. Many of those people ended up taking time off from work or having this crash affect their lives in other ways. And of course, for Jeff Lose and everyone involved in the On the Loose cruise business, they suffered a loss of livelihood as a result of this crash. Their business has not been able to reopen in the last 2 years. But even more than the physical injuries suffered by these victims, this was scary for them. This was scary for all of them. No one on board the On the Loose expected the biggest boat on the river, this big party boat, to be hit by a huge speedboat when they were out for a cruise. Multiple people testified that they were unable to swim, and even more who didn't testify also had that same experience. For some victims, this was their first time on a boat, and frankly, for a lot of them, I think it was their last. For the people who were on the front deck of the On the Loose cruise, which was the bottom part where the impact happened, the defendant's 48-foot speedboat passed within feet of their heads, going more than 45 miles per hour. This was really scary for them. People were knocked to the ground, they were confused, it was chaotic on board after the crash. Nobody knew if the On the Loose was sinking or if the other boat was sinking or if there were people in the water. And in the aftermath of this crash, multiple victims, those who were physically injured, those who were not, have had to deal with PTSD, with lasting mental effects from this crash. Some have nightmares. As I said previously, many of them don't want to go on a boat ever again. And to kind of reiterate the theme of the trial, this is not about victims lying because they want to get something out of the defendant. This is real. The defendant's boat went up on top of the On the Loose, right where people were standing, right where people were sitting. The defendant is lucky that there weren't more people injured, and he's lucky that the crash happened in the way it did. He was making this wide turn, and that the wide turn he was taking didn't take him straight up onto the bow of the On the Loose. If it had, people certainly would have died. He's lucky that Jeff Lose was able to pull over quickly, and he's lucky that there weren't people in the water, that nobody was sitting in the chair that ended up mangled right underneath where the impact happened. And I use this wording on purpose because although some of the people who were on the Loose believed that, or they perceived his driving as being an evasive maneuver at the last moment, that is not what the evidence showed, and it's not what the experts said. He came onto the bridge, went right, left, right again, and then did a big sweeping turn to the right. And the On the Loose was right in his path. He didn't do anything to avoid it, and that is consistent with the evidence. So although this crash didn't result in death or in serious injury to anybody, it is not because of anything the defendant did. It was just luck. Now, there were a number of victims on the Loose who didn't testify at trial, and some of them submitted victim impact statements, which I'm sure the court has seen. I'd like to bring up one of them, victim number 43, who submitted a statement. He was on the top deck of the boat with his wife and his disabled daughter and a family friend. There was talk during the trial about what efforts it took to help get the disabled daughter down the damaged stairs and down from upstairs after the crash. This victim is an older gentleman who was thrown to the ground in the crash, and in his statement he said he had pain for over a month. He was clearly affected by what happened. He was clearly outraged by the fact that the defendant fled the scene after causing something that was so traumatic. And he was in a position to be in just about as far away from the actual impact as possible and still be on the loose. He was on the upper deck in the back. Victim 43's friend, victim 47, also submitted a victim impact statement. She was near him on the top deck of the boat at the time. She wasn't physically injured, but she was clearly very affected. Her dramatic language that she used in the victim impact statement asked questions like, did you see us before this happened? What were you thinking? And clearly it is something that she was thinking about, although she was not physically injured in this crash. It's something that she carried with her afterwards. So my point, Your Honor, is that these victims take their stress and their pain and their fright and whatever they experienced in this crash with them wherever they go. Their families see it, their friends see it. And it can't be understated that the on-the-loose cruise business, which for years was a common sight in the summers on the Fox River, it hasn't been able to run since July of 2022. Thousands of people could have enjoyed a cruise on this boat, but the defendant's choices spoiled that. And of course, Jeff Lose and his family have felt the economic strain of that ever since that day. So my point, Your Honor, is that when you think about the seriousness of the offense, it's not just the choices that led up to the driving and the facts of it, it is the wider impact. And this crash had a wider impact to what the defendant did than what was shown at the trial. And that impact doesn't just stop with today's hearing. Some will feel these effects for years to come. Now, another aspect that the court is required to take into account is the character of the offender. This defendant has no prior criminal history. He was charged with a criminal disorderly conduct in Brown County in 2007, but that charge was amended to a forfeiture violation, and he pled to that in 2009. In terms of his driver history, he has a seatbelt ticket from 2021. He does have an OWI first offense in a motor vehicle that he was convicted of after a jury trial in July of 2017. His driver record also shows that he was arrested by the Oshkosh City Police Department on October 31st, 2008 for an OWI with a blood alcohol concentration of 0.19, but there was no charge associated with that offense. So truly he has no criminal history as he comes before the court today. However, it is clear that he had been drinking on July 9, 2022 at the time of this offense, and that he had been drinking all afternoon and all evening. There were testimony at trial from people who were not his friends who observed him drinking at Stretch's sandbar throughout the afternoon. They also saw him stumbling, falling off the ladder to his own boat. There was testimony from the two sisters who didn't know him and sat next to him in his group at the Dockside Tavern just prior to this crash happening, talking about how how the group was taking shots, that they appeared to be impaired. And of course there's the Dockside video, which we all saw a lot of at trial, which shows the defendant dancing, high-fiving, hugging, and holding multiple beers. Maybe he had been more drunk in his life, as Ms. McDaniel testified at trial, but he sure wasn't sober when he drove his boat that night. And frankly, Your Honor, this shows a treatment need, this coupled with his history that I just explained. Moreover, he has never taken responsibility or shown remorse for his actions that night. He never acknowledged that he was drunk at the time of the crash, or that he had even been drinking. And frankly, he claimed at trial that the beers he was seen holding in his hand were actually water. He never stopped after the crash, and while that is part of the seriousness of the offense, it is also part of his character, which is why I place it in this section of the argument. He never stopped after the crash to check on the people on the loose. He just took a slow pass, kept on going. He tried to say at trial that he needed to flee the crash because he was afraid for his safety, but there was no credible evidence showing that the people from the on the loose threw anything towards his boat or that they said anything to him beyond, hey, get back here, there are people who are hurt. Now, there was the issue of Brian Anklam, who chased the defendant's boat after it left the scene, but he chased it after it had already left the scene of the crash. It's clear that the defendant had no intention of stopping where the On the Loose was after the crash. There was some concern at trial about Brian Anklam calling defendant and people on his boat fuckers and saying, "You better stay here." But, Your Honor, the testimony that came out showed that that happened as the defendant was heading out into Lake Winnebago after dropping his passengers off at the Leach Amphitheater. So what happened was the defendant took that slow pass past the On the Loose, and he saw the chaos that was happening. He saw that people were on the ground, that people were injured. He didn't know how many people were injured or to what degree, but he knew it was bad. And he ran away so no one would know he was drunk. He chose protecting himself over helping others. And then he took his two good friends out into Lake Winnebago, where he spent the night. They spent 7 hours and 20 minutes out there, according to the GPS. Both of his friends, Matt Pianola and Jackie Walton Cumbier, testified at trial that they didn't talk about going out in the lake or how long they were going to spend out there or whether they were going to stay overnight or anything about the crash at all. But that's not credible, Your Honor. And this is part of his character too, the fact that he left and kept on going. Now, he did let some people off of his boat after the crash. But he could have done so much more if he had wanted to take responsibility for what he had done. There were ample safe places for him to stop between the area of the crash and and frankly, between there and 5:45 in the morning when he abandoned his boat at the Pioneer Marina. He never called police, he never called an ambulance, and never asked anyone else to either. He did not want to know the extent of the damage he caused. He did not want others to know that it was him who had caused that damage. Several people who were on the Loose boat, both at trial and in the victim impact statements that were submitted, have said that they were worried not only about the people on their own boat, but they were worried about the people on his boat too. Contrast that with the defendant, who didn't show that same level of worry. He did, however, show through his actions that he was conscious of his guilt. First, he let the Dons and Kaylee and Connor off at the Leach Amphitheater, which is across the river and down a little ways from the dockside. This is important because they had left from the dockside. The Dons left their car at the dockside, and now they were forced to walk back from the Leach Amphitheater back to the Dockside Tavern to get their car before they could go to the hospital even. Shelley Dawn testified that she only had one shoe. Troy Dawn was bleeding from his head and his back hurt so bad he could hardly stand up straight. According to Google Maps, it's a 13-minute walk at a normal pace from the Leach Amphitheater to the Dockside Tavern, but I bet it took him longer. And again, the defendant did this. He made this choice to leave them at the amphitheater instead of at the dockside, where he knew there were people there who could help them right away. He knew that there were slips where he could park his boat. He did that specifically so that he wouldn't be seen. Again, placing himself over the protection of others. Another boater heard him say before he went out into the lake, "I'm so fucked, I'm so fucked." That also shows consciousness of guilt at that time. And of course he did leave and spend the night in the lake and abandon his boat in the morning. And we can't forget the testimony about his phone. That night, we know he didn't answer numerous calls and texts from his daughter Madison. We know he deleted all calls and texts on his phone from the night of the crash, and he did that before the police had a chance to look at his phone. And he set up that calculator data vault so that if somebody tried to access it without putting in the proper passcode, it would reset the phone to factory settings and delete all the information on it. And although he didn't take responsibility that night for what he had done, he had a larger responsibility at the time of this crash. First, of course, to the people on his boat to keep them safe. Sure, his friends were with him partying all day. They knew what he'd been doing. But there were 2 people on his boat, Kaylee and Connor, who were under 21. They were in town for a visit from Arizona. And the Dons, who truly were along for the ride. They were innocent. They knew that he'd been drinking when they got into the boat, yes. But he was still responsible for their safety. Just like a driver on the roadway, you are responsible for the safety of the people who are inside the vehicle with you. Plus, he has a local reputation to keep up. He owns businesses on the Fox River. He owns a marina. He sells performance go-fast boats. And he has a reputation in the community for driving those boats or organizing events like the poker run that involve boats like that. For being involved in the boating community, for being a prominent businessman, and for donating and being part of local organizations like the Boys and Girls Club. We read about that in some of the letters that were submitted on his behalf. And that local reputation factored into his behavior last night. But what it means is that he should have stopped. He should have shown the leadership that people see from him in business and in the community. He should have helped others, but he didn't. He was only looking out for himself. Some people who wrote in on his behalf asked the court to not treat him any differently from any other people, and that's exactly what we are asking here today. Do not treat him any differently than any other defendant that comes through here with similar charges. However, the court does have to consider the galleon factors and individualize a sentence that works to protect the community from Jason Lindman, to protect the victims that he harmed, and to impose a sentence that is right for the community who has been watching. Some of the letters that were sent in on his behalf paint a picture of a family man, a prominent businessman who gives back to the community, donates to organizations that help people in need. But in a time of stress, he showed his true colors. He's a leader in the community, but he didn't show that leadership on July 9, 2022. He cares about others, but he didn't show that on July 9, 2022. And he loves his kids, but he hung up on his daughter when he knew she was with the police on July 9, 2022. This crash was 100% preventable, but the only person that could have prevented it was the defendant. In terms of protection of the public, we talk about specific deterrence, right? So the defendant is a specific deterrence referring to the defendant. And of course, the community is more protected from this particular defendant if he is sober. He has clear treatment needs in the area of alcohol and drug abuse. His history shows that. His actions that night show that. Clearly, because of his prior arrest for OWI and conviction for OWI, alcohol has been problematic in his life before. He has had no violations while on bond. He was on monitoring until March 13, 2023. Hasn't been since then. But what I think is notable is that none of the letters from people who truly know him acknowledged that he had a problem, or mentioned that he's done any treatment, or even mentioned that he has abstained from drinking alcohol since this offense. So I think we can assume he has done no treatment. Abstinence isn't the same as completing treatment if he has been abstinent, but an assessment will help identify what his treatment needs are, and will, following through with treatment, will help protect the community from him in the future. Another aspect that will promote public safety is restitution. And obviously this has been set for a restitution hearing, that the number of that is going to be discussed at a later time. But of course, there was property that was damaged, there were people that were injured, and there were multiple people beyond even those who were physically injured and who testified at trial about those injuries that may have suffered some out-of-pocket monetary expenses associated with this. Generally speaking, restitution is part of rehabilitation, and we believe that it should be ordered here. Now, we don't usually talk about general deterrence in the criminal context, and a lot of judges don't believe that general deterrence really works. But the community has been watching this case, and if there is any case in which general deterrence can be effectuated, where the community would see that something happened that they probably don't want to have happen to them, they might make different choices in the future because they know the defendant or know of the defendant, and because they're appalled by this behavior, because they want the court to do the right thing, to impose an individualized sentence. General deterrence might work in this case. This is a community of voters. It's a community of people who, even if they're not voters, see voters come through here a lot, especially in the summer months. This community knows who the defendant is. They watched the jury hold him accountable for the damage that he caused, and they are still watching now. Of any case, this is a perfect example of when general deterrence could happen. People in the community will see what this court decides to do. They'll know that there are consequences when you drink, when you drive your boat too fast, when you don't watch where you're going, and you injure other people as a result. They'll see that it's not worth it to leave after a crash, that it's probably a better choice to stick around and try to help people do the right thing. Now, the court is required to consider probation first, and we believe that that's appropriate in this case, and in fact, obviously, that's what the state is recommending. Although this is a serious offense, we believe that the imposition of probation does not does not depreciate that seriousness. We think the length of supervision that we're recommending reflects his treatment needs and his need to rehabilitate himself in the community, and restitution is part of that as well. It also reflects the public's need to have him under supervision for a period of time to make sure he doesn't do something like this again. Punishment is also an appropriate consideration for the court, and conditional jail fulfills that. Again, this is something that the community needs to see, that the victims need to see, that is part of showing this defendant that his actions were preventable, that he did do something wrong on July 9, 2022. And the conditions that we're recommending are designed to protect the public and at the same time make sure that the defendant doesn't do something like this again. So what it comes down to, Your Honor, is that what the defendant did on July 9, 2022 affected a lot of people. All the people on both the boats, their families, other people in the community, and also every other boater that was on the water that night. Every person who saw him at the sandbar earlier, every employee at the dockside. His actions affected this community in which he has been a leader. They affected and continue to affect the lives and the families of the people who were involved in the crash with him. He needs to be held accountable for his actions, for the choices that he made that led him to this result, to this preventable result, to this foreseeable result. The community needs for him to be on supervision, to pay restitution, to have to learn to be a safer boater, and for him to be punished. And hopefully he will not make these same choices again. So with that, thank you, Your Honor. We ask that you accept our recommendation.
I believe there may be some victims that wish to be heard on the matter. If you do wish to speak, please raise your hand and the bailiff can bring the microphone to you.
Yes, the first speaker is victim number 7.
Okay, victim 7, you may go ahead and address the court.
Thank you for the opportunity to have a voice and verbalize how this has impacted my life and so many others in the case. It has been 775 days since July 9th, 2022. I have carried this crash with me every day since. The impact to Jason's life this far is less than 1 day in jail during his initial intake, a minimal cash bond, and his court-ordered sobriety. Every victim continues to live each day with his reckless choices and will carry it forever. I am asking the court to give Jason the maximum sentence for his actions and choices that night. He has shown no care, concern, or compassion for the victims, not a smile, a glance, or an admission of guilt. His lack of integrity to do the right thing at any point in this entire process, from the initial 3 days it took him to come forward, to all the hearings, and his defense team's closing argument strategy. On the night of July 9th, there was a reckless crash that Jason's powerboat in our chartered birthday celebration cruise. And we spent a lot of time dissecting the events of that night. But today we are here to hear the ripples of the waves that occurred after the collision. Each wave represents a victim that continues to carry this impactful event, even when it's not visible on the surface. Through all the doctor's visits, the therapy sessions, the sounds and smells of the water that bring us right back to that scary night, the pain, the anxiety, and the distress continues to follow me every time I hear a boat race by. It has impacted even where I work due to the sounds of the accelerating boats. Every court hearing, conversation, media report, or reminder of that day brings me right back to that evening. The unexpected blow of this trauma was during the jury trial as the defense team attacked the character of each of the victim counts. The victim shaming increased the impact of this tragic event. There were so many victims in this case, and all those he has impacted on every level. He truly changed many people's lives with his unmoral behavior and lack of accountability. Jason, I hope you can find a way to be compassionate and show remorse and concern for all the impacted people voting that night, celebrating the working staff that night, including the Luz family, the police and emergency teams, and anyone who was on the river that night on July 9th, 2022. I will carry this burden for the rest of my life, along with many of the other victims. It has changed my life and will continue to impact many things. I have attended most of the hearings and listened for every opportunity to see remorse or a glance of concern with no result. Your actions will continue to impact me as one of the scariest nights of my life. I am working on forgiving you so I can have some closure and peace. Respectively, I ask that you hold Jason accountable to his actions and choices with the maximum sentence today for all the victims in this case, including the ones that are silent as a result of the trauma. Thank you.
Is there any other victim that wishes to speak at this time? Now, if you do come up here, you'll be on the camera. You come up to the witness stand. And which victim number are you?
I'm not sure. She's number 11.
So victim 11, go ahead.
There are two types of people in this world, the ones that run towards an emergency to help and the ones that run away from it. You, sir, are one that runs away from it. I'm a caregiver by trade and at heart. That night was supposed to be about fun and reconnecting with old friends. Instead, it turned into chaos and absolute insanity. I know you did not set out to ruin people's lives that day, but your choices definitely did. You and your lawyer spent the past 2 years victim blaming. making all of us feel like we were making everything up when you, sir, were the one creating the narrative that suited you. That night, the last thing I remember before the crash was turning my head to talk to my friend on the boat and getting hit at 46 miles an hour with no idea we were going to get hit. There was no bracing, I didn't see you coming, I just got hit. I flew back and I hit my head. My friend and I held on to each other's arms as our chairs swung side to side. Then we fell forward, hard to the ground. You like to say you're making it all up, but many of us were hurt. Your lawyer pointed out that I said I was running on adrenaline and talking calmly to the police officer on the scene. That is the way I conduct myself in a high-stress situation, and I'm proud of that. You, on the other hand, ran away from the situation you could have helped with. How hard was it to pull over and see if someone needed help? The first words out of my mouth after the crash were, "Where is the other boat? Are they okay? Were there any kids? Is anyone in the water?" I immediately wanted to help others. The first thought of yours, Mr. Lindman, was how can I get out of here without getting into trouble? Your boat drove right past me as I yelled to please help us. Did you stop? No. You just kept going. You cared about you, not us. For your information, I spent months going to doctor's appointments, chiropractic appointments, dry needling, etc., so I could do everyday things like lift my kid over my shoulders, climb a tree, or be able to walk my dog, work, and just live my life without pain. I also had a concussion, cuts and bruises, and extreme anxiety after the crash. The pain in my shoulder still comes and goes. It's a constant reminder of that terrible night, the night that should have never ended that way. I know you love to downgrade the situation, but honestly, it was one of the scariest situations of my life. I really feel if you would have hit us a couple feet over, none of us would be here. We all sprang into action, helping injured people, my husband helping people off the boat that needed assistance. I was also smart enough to take pictures to document what was happening, although your lawyer turned that around as well and made it seem like it was a calculated move with ulterior motives. I was so scared that night that I called my kids and my mom from the shore because I needed to hear their voices. That night, many people could have lost their lives. Families could have been destroyed because of your stupid move to drink and drive a huge boat. While I'm happy to be alive, my life is forever changed. I just want you to know that whatever story you and your friends made up is not the truth. Who the hell goes and spends the night in the middle of the lake on their boat if they didn't have something to hide? I am glad that after today we will get some closure and hopefully put this awful day behind us. I also hope that you do get punished for your crimes.
Is there any other victim that wishes to speak? Okay, you are victim number 31?
31.
Okay, go ahead, sir.
Good afternoon. My name is Jeff Rose, owner and operator of Honolulu's Cruises. In the past 2 years, I have been paying close attention to the proceedings related to the boat accident on July 9th, 2022. In that time, I have attended many court hearings, noting that Mr. Lindman has yet to admit responsibility or show remorse. On the last day of the trial, it was stated by his attorney that Mr. Lindman is a good man and a businessman in the community. If he is such a good man, he should have made full restitution to all the victims within this time. But to date, there has been no move to do so. A good and moral man would admit his mistakes and try to assist his victims in recouping their losses. I myself had considerable financial losses. I personally am paying for all the business expenses, lawyers, accountants, dry dock fees. Operating Honolulu's Cruises was my retirement plan. I am now 70 years old, 2 years into retirement, still no boat or business to operate, and worst of all, loss of my retirement goals. The boat itself requires extensive repair to pass the Coast Guard certificate of inspection. In addition, I have had to relinquish my Coast Guard captain's license due to the lack of required annual hours of vessel operation. To regain such licensing will require recertifying through proper Coast Guard reclassifications, training at a cost of time, testing, and expenses. Mr. Lindman made a choice that night to leave the scene of the accident. Knowingly, people could be injured for this, For this reason alone, he should get the max jail time, max fines, and pay full restitution to all victims.
Is there any further victims that wish to speak at this time?
Yummy.
Sorry, not sir. Keep up.
But, you know what, I really don't care if he gets jail time or probation or just has to pay a fine. No matter what, he's not going to suffer. He still has all his businesses and all his income. And I have no boat, no business, no income. Not done.
Thank you, sir. Is there any further victims that wish to testify at this time or speak? Seeing and hearing none, Attorney Siller.
Thank you. Your Honor, regarding the seriousness of the underlying offense, the court's well aware. Probation is where the first thing to be considered here. I appreciate the state's conceding that this is a probation case. Jason is a probation defendant. Regarding what was said about deterrence, that's not really one of the gallant factors at all. I know sometimes that can be taken into consideration, and courts often do. At the start of this case, following this accident, which is what this was, the state conceded as much in their rebuttal closing argument. A false narrative was put out there on social media that spread, and it went through, picked up by the media, and it was run through, and it's currently still ongoing today, that following this boat accident, Jason sped off without making any attempts to see if there was anybody in the water, without ever coming back to the loose. And if there's one thing that clearly came out at jury trial was that is a false narrative, that after the accident, there's testimony that the first thing Jason did, I believe it was Mr. Down testified, was asked if everybody in his boat was okay or if anybody was injured. And then after that, they motored back. And I believe Mr. Down stated that then they realized, nobody had known what they'd hit, but they had realized, seeing the paddle wheeler pulled over, that they impacted that boat, and then they made their way back to it. And there was still video evidence of that, of Jason pulling up alongside the loose. One of the state's witnesses testified that he described it as it came to like a standing idle alongside the loose before somebody from the boat hollered that we're going to go downstream, and then they proceeded downstream. Had this been what's been widely circulated by the media and on social media, where Jason smashed into a boat and not had come back to see if there was anybody in the water, it would be a different type of sentencing, because you're talking about something that's more than just an accident. You're going from really something that's mala prohibita to almost mala insane, in that it sets a different scene. It's not what happened, and it's unfortunate that it has not been picked up. After that became clear at trial that after this accident, Jason did return, did slowly go through the water and approach the loose to see if there was anybody in the water, and there was nobody in the water. The state asked that the court treat Jason no differently than anybody else, and that's what we're asking as well, Your Honor. We agree probation is appropriate in this case, and we're going to ask the court for the same. Across the state of Wisconsin, Judge, court tracker data analysis shows for people convicted of second-degree reckless and dangerous safety who have no prior criminal convictions, the vast majority receive probation. Approximately 80% receive probation. Doing a random analysis of those who did not receive probation had other aggravating crimes associated with the second degree. Chapter 940 offenses, strangulation, sexual assaults, things like that. Of the approximately 80% of everybody who receives probation, half of those receive just probation without any conditional jail time. Approximately half of the 2,176 cases that receive probation 1,022 received some form of jail. The balance had not, so over half did not receive probation. The vast majority of those received from 1 day to 3 months. I have that information. I can provide a copy to the court. If the court would like it for the record. So we are asking the court to treat Jason the same, to not to impose probation in this matter. When talking about what level of probation or conditional jail time or how serious this event is, not underplaying anything regarding the seriousness of the underlying event, but I think it's important to remind the court, we had a motion hearing during the middle of the trial about the testimony of Deputy Thomas Burns. He was the county's lead Marine deputy. He's the officer who drafted the DNR crash report, and he was on body cam the next day stating had Jason just stayed, he'd be looking at getting a ticket. That was his opinion regarding this. And I just offer that out there because he's one of the senior investigating officers on the case, again, who stated, drafted that DNR crash report, and that was his opinion of this accident. But as the court's well aware, and it's come out of trial and been argued by the state, after Jason came back and checked on the boat, there was nobody, seen that there was nobody in the water. He did motor away and ultimately went out to Lake Winnebago. The state's brought up some of the testimony at trial. I certainly disagree. Specifically, they made 2 allegations of claims Jason made at trial. The court's well aware Jason didn't make any allegations at trial. The state argues that he was intoxicated when this accident happened. No officer issued an OWI citation. There was no evidence that he was intoxicated. I believe it was December 2022, the prosecution ordered an OWI citation be issued to Jason, and so the deputy did as ordered. However, as the court's aware, prior to the commencement of the case, the state's moved to dismiss that citation based on a lack of evidence that came out at trial. The fact is, they had a video of Jason sidestepping, going around a table inside of his restaurant dockside. Jason had a full right hip replacement in 2010, and October 7th of this year, he's got the surgery scheduled to have his left hip replaced. The state talked a lot about the character of Jason, and that's certainly one of the relevant galleon factors for the court to consider. And they asked that the snapshot of what happened this night be the totality of this man's character over the past 54 years. Shocking accident. We all would hope and speculate we'd act a certain way after something like this has occurred. But the fact of the matter is, Jason's a 54-year-old man. He has no prior criminal record. He served 8 years in the Navy as a corpsman, which is essentially a medic. He's been honorably discharged. He was highly decorated. After he was discharged from the Navy, Judge, Jason got a job in Evergreen retirement community working as a CNA. And he worked as a CNA for a significant period of time. And the court's probably well aware certified nursing assistants are really at the bottom of the pecking order of these retirement communities. They're responsible for direct patient care, cleaning, bathing, feeding, all the things that nowadays these facilities are having a hard time finding people to do. And that's what Jason did when he got out of the Navy after serving 8 years. The then director of Evergreen was a man named David Green. He recognized Jason's work ethic, his talent, his abilities, and the CEO of Evergreen actually took the CNA under his wing, mentored him, and brought him up into the household residential living plan that most of these communities today are now made up, basically going away from institutionalized care to now residential facilities. Jason worked his way up from a CNA, eventually becoming a manager of a long-term care facility. then got promoted to quality and assurance, and eventually in 1999 from scratch started his own business and started his own residential care business that today now has grown to employ approximately 2,000 people. So it's a very impressive story. It's an American success story. He accomplished all of this while battling dyslexia his whole life. And then, as the court's well aware from the trial, he also owns a marina and a dockside restaurant. He has 4 children. His first grandchild is due on the way the first week of September this year. As I already stated, he was not intoxicated. He's had that hip replacement, and he's got the next one scheduled this October. I know there was a letter submitted by this Barry Johnson that I don't know how that got filed by him or who he is. It apparently was an unsolicited letter, at least from our side. He stated he believes he has AODA issues. The state made an argument that Jason has AODA issues. I don't believe that was at all evident from a jury trial testimony. In fact, the evidence before the court proves to the contrary. Jason spent 244 days on the 24/7 program. That's unprecedented in this country. I'm not aware of anybody else ever being on the program that long and doing it successfully. 4 times a day testing, and he never had an issue. That in itself demonstrates that he does not have AODA issues. Your Honor's been in the business long enough. We all have to know that somebody that has AODA issues is not going to go 244 days without missing a blow or having a hot blow. No bond violations for the past 700 and I believe it was 73 days since this incident. This all leads to there's no need to protect the public from Jason Lindman. The court has to consider that as the final guiding factor. And I would like to direct the court's attention to some of the letters that were submitted on Jason's behalf regarding his character, because it does directly go to the need to protect the public. You have the letter from Mr. Ganther. He writes how Jason throughout his life has supported charities such as Father Cars, the Place to Be, the Christian Ann Center, the Boys and Girls Club, just to mention a few of them. Mr. Schwab also wrote a letter to the court, and he acknowledges the same generosity of Jason throughout his life here in the community as a benefactor to the Boys and Girls Club, to Christian Ann Center, and numerous other organizations. Same with a letter that was submitted by Jeff Lindman, as well as he also notices found that Jason's a provider to the Special Olympics, the Oshkosh Food Pantry. And I think it's really telling of Jason's character when you look in here in this letter where he mentions how he was reluctant to advise the court about this, knowing that Jason would be upset if it became public, but how he supported this family and covered the funeral expenses of this child that was tragically killed in an auto accident. And that's just says, it's a remarkable attribute of this man, and it's common characteristic of him. Got a letter from Jim Dane, the executive director of Father Cars Place to Be, attesting to Jason's patronage of that charity. Mr. Gaffner talks about Jason's contributions towards children in the community, providing free busing to Milwaukee to see the Shrine Circus. Attorney Nate Olson, local attorney, writes to his attributes, and of course, family members regarding his commitment to his family, which has been demonstrated. There's a lot of people here in support of Jason today as well, which also shows that this is a valued member of community, and that is what his true character is. One letter, and Sherry is not mentioned in there, is there's been discussion here about how he should never be able to operate a boat again and things of that nature. Jason also organized a boat charity called the Four Horsemen Group, and that charity has provided in the past approximately $500,000 to Children with Cancer, the Boys and Girls Group, and specifically funded cures for one child with cancer in Wisconsin Rapids that is in recovery as a result of the help and the finance received from this voting charity that Jason is operating. During the course of this case, from the misinformation that was put out there on the front end and that prevails today, the courts have actually had to intervene and protect Jason and his family from members of the public. 2 restraining orders have been granted for threats that were made against Jason, for threats that were made against Jason's family, because there's perception out there that he never came back to check in if there's anybody in the water. There's been efforts to cancel his businesses online, to boycott him. And as the court's well aware, Jason faces multiple civil lawsuits now, many of them seeking punitive damage as well that will further provide punishment. There will be a restitution hearing. The court asked on the front end, are we contesting the restitution? And our answer at this point has to be yes, because it was just on Friday we were made aware that restitution was being requested, and we got these 80 pages of documents dumped on us. And of course, that's something that we'll have to go through, and we'll see what is contested and what is not. And certainly any restitution that's ordered by the court would be a condition of probation. So we're asking that the court do exactly what the state asked as far as treating Jason the same as everyone else and place him on a period of supervision. I do think that's consistent with somebody convicted with no prior criminal record of second-degree reckless endangering safety being the focus, the felony offense. This is a man who's, like I said, no priors, and now, as a result of this, is now facing a felony conviction as well as significant hardships that he's had to deal with. And you know, he understands he's responsible for his actions, but I don't think it's fair to say that he's had no consequences over the last 2+ years, because he certainly has. And he has demonstrated that he is not a risk to the public. He has no AODA issues. So we're asking the court as to count 1, withhold sentence, place Jason on a period of supervision for a period of 18 months, with a condition to abide by any counseling treatment deemed appropriate by the agent, any restitution, should restitution subsequently be ordered at a restitution hearing, and the same concurrent probation as to count 2, 18 months, and then 12 months probation concurrent with all remaining counts as to count 1. Somebody who's no priors, as stated, who's been an outstanding member of the community, a pillar of the community, not by his great successes, but by his charity and by his example in his otherwise everyday life. He was arrested. He has 2 days jail credit for this matter. And we believe that supervision in this matter is appropriate. It's consistent across the state with people convicted of similar charges. Can't really say, you know, factually, no 2 cases are ever factually the same, obviously. But this does not have any of the other Chapter 940 incidents around it, like more serious events. This was an accident. The state conceded that. Everybody knows this was an accident. This wasn't anything intentional. And thank you for your consideration.
Mr. Lindman, is there anything that you wish to state to the court at this time? The microphone close, please.
Your Honor, after the accident on July 9, 2022, I didn't know what we had. Someone on the boat said that they thought we had a buoy. So my first concern was if anyone was injured on my boat. After checking on the people on my boat, I saw the loose docking downriver and realized we must have collided with them. I navigated my boat back towards the loose location, checking if anybody was in the water along the way. Not seeing anyone in the water, I pulled alongside the loose as best as I could with 2 working engines and compromised steering. I yelled out to them, I didn't see them. At the time, I didn't personally see anyone injured on shore. One of my passengers had a cut to his head and needed to get off my boat. There was no place for me to dock there, and then Matt on my boat said somebody's throwing bottles at us, and there was yelling. I then yelled out that we were going downstream. I didn't have control of my boat enough to dock in a slip at the marina because of the current of the river. I needed a long parallel shore down by the leach to drop off my injured passengers. At this point, I don't know what I was thinking. I wasn't intoxicated. I had just been in a shocking accident. Admittedly, my thoughts turned to self-preservation, my pending divorce, and the impact this would have on it. So I regrettably left the area. I sit here before you today with a heavy heart, fully aware of the gravity of my actions and consequences and they have brought upon myself. I want to express my deepest remorse to Mr. Lose, his crew, and all on both vessels the evening of July 9th, 2022. I understand that my actions have not only had an impact on the people involved, but also their families, my own, and the community at large. I take full responsibility for my actions and consequences that have followed. There is no excuse for what has happened, and I'm not here to seek pity or minimize my conduct. Instead, I am here to offer my sincere apologies and to ask for the court's understanding and mercy. Over the past 773 days, I have had ample time to reflect on my actions and issues they've caused. I've taken steps to better my actions through counseling and self-reflection. These efforts are part of my commitment to becoming a better person and ensuring that I never repeat the mistakes of my past. I understand that words alone cannot undo what has been done. However, I hope my actions moving forward will demonstrate my genuine remorse and dedication to making amends. I'm committed to contributing positively to this society and making a meaningful difference in the lives of others. I respectfully ask for leniency in your sentencing, Your Honor. I am prepared to accept the consequences of my actions. I also hope for the opportunity to prove that I can be responsible and a member of this community. I'm determined to use this experience as a turning point, and I'm committed to making the most of any second chances I've given. Thank you for your time and consideration.
This matter comes for sentencing today. The defendant having been convicted of 2 counts of second-degree recklessly endangering safety, 11 counts of boating accident causing injury and failure to render aid, and 1 count of negligent operation of a boat. The conviction came following 8 days of a trial. The maximum penalty for this offense is 28 years and 9 months of incarceration. It would be bifurcated due to the 2 felonies for 18 years, 9 months of initial incarceration, and 10 years of extended supervision with a total fine of $160,000, $160,200. I think both sides concede that this is not a prison-type case. The state is recommending 6 years of probation, along with 9 months of conditional jail time and some additional counseling and AODA assessments. Defense recommends 18 months of probation with no jail time on the 2 felonies and 12 months of probation on the misdemeanors. The court has heard the arguments of counsel, statements of the defendant. I also reviewed letters from members of the community in support of Mr. Lindman. They came in from his family and various individuals indicating that Mr. Lindman is community-oriented. He helps out local nonprofits, and that he has learned much since that day and made some changes. Mr. Lindman indicates the same today. Also reviewed the victim impact statements from V1, V6, V10, V11, V18, V21, V24, V29, V32, V43, and V47. V26 and 31 both indicated they would send something at a later date. And V31 did speak today, along with V7, 11, and 3. The victims, as a general tone, all indicated that they are still dealing with the trauma that occurred that day. Some of them have fear of being on a boat. Many of them have physical issues that they are still dealing with, medical bills that are still being incurred, time off of work, lost wages. But most of them, the primary issue they indicated was that they wish that Mr. Lindman would have just stopped and rendered aid. As we turn to the facts of this case, the voting community is a tight-knit community. We heard witnesses from several parts of the state that are drawn to the waters of the Winnebago system. The state started this case by quoting, "With great power comes great responsibility." Here, we have a large powerboat with 4 high-performance engines. In that boat was Mr. Lindman, along with 6 passengers. Certainly, if he were operating a small fishing boat or a canoe, we would not be here today. But he struck a large passenger vessel, that being the On the Loose cruise vessel. It contained 41 passengers, along with 3 crew members. It is likely the largest passenger boat on the Winnebago system. So Mr. Lindman affected 50 other people's lives that day. And had he just stopped and rendered aid, we may not be here. It would have potentially been a week-long story about another accident that occurred on the water, because it is a reality of what happens. People party on the water, boaters go to sandbars, bars, restaurants on the shoreline. Sometimes there are accidents. Several of the witnesses that testified were drinking at the time of the accident, but they were not driving at the time. Unfortunately, some boaters do drink and drive. Some are over the limit, some are not. I'm not sure if that happened here. It certainly seems highly likely that it occurred. It's not okay, it's not excused. But the boating community acknowledges that this is a risk of being on the water, and to some extent accepts that risk. Mr. Lindman was drinking something. I'm not sure how much, whether he was drunk. I'm not sure, because he fled the scene. That's the reason why we are here, and why this case has rendered so much attention. It isn't so much the accident. We're here because of the failure to stop and render aid. That's 11 of the counts that Mr. Lindman was convicted of. We heard testimony from Captain Mouse about a pan signal going out over the emergency channel. Other boats flocked to the scene, but Mr. Lindman left the scene. First in a slow idle, then into the darkness of Lake Winnebago. This is obvious from the video footage as well as the GPS data. There were some reasons that were alluded to about threats from the shore, possibly a bottle being thrown, scared of a mob that may come. That was primarily testimony from Mr. Pianola. He didn't remember much else about that night. Brian Ingram did admit on the officer's body camera that he was swearing at the boat. He was doing so while pleading to stop. Even if these threats were made, there were so many other options that day. Sit in the middle of the river, drive a short distance away, telephone the police. We heard testimony from the other boater, Brad Johnson, pleading to stop as he was following the Lindman boat, stating, "Jason, do the right thing." There were pleas from the shore of the Fox River to stop. Even in Mr. Lindman's own boat, Miss Aarons was asking to stop the boat. We heard from Madison Lindman asking over the phone, "Where are you?" Your actions that day were cowardly, and that is what is most offensive to the boating community. In considering an appropriate sentence, there are several general objectives that come into play. The court must consider. One that was discussed here was protection of the community. Another one that must be considered is punishment of the defendant, as well as rehabilitation of the defendant, deterrence to others, restorative justice, as well as victim restitution. I think of prime importance in this case are both punishment to the defendant as well as the deterrence to others. The sentence of the court today advances these objectives by both punishing Mr. Lindman for the actions on that day, but also sending a message to the community that if you don't stop after an accident, you will go to jail. In arriving at the sentence, the court considers past criminal offenses. Here, Mr. Lindman doesn't really have any prior criminal offenses, nor does he have a history of an undesirable behavior pattern. His personality, character, and social traits are all that he is a productive member of the society and certainly donates to a lot of non-profit organizations. It's not a vicious or aggravated crime. As to the degree of culpability, certainly there was not much of a degree of culpability at the scene, nor when text messages were erased. Today, Mr. Lindman does take some responsibility. The court also must consider the age and health of the defendant. He's a middle-aged man in general of good health, also gainfully employed as a business member in the community. The court must consider the remorse, repentance, and cooperation. That is a mixed bag in this case, as there's been some remorse recently, but certainly not in the beginning hours of the accident. The court also must consider the need for close rehabilitative control. Alcohol does seem to be an issue here and need to be controlled. Mr. Lindman did, during the course of this case, go for an extended period of time with no violations on the 24/7 monitoring program, as well as no bond violations, so the court does factor that in as well. The court must also consider the rights of the public. Here, one of those rights is to gather information following an accident and to get the insurance information quickly. That was deprived of the victims in this particular case. There are no aggravating factors that the court notes in this particular case, but there are several mitigating factors, as I indicated. The court going through this detailed analysis because sentencing is a very personal thing, and it's unique for each defendant. The court has to impose the minimum amount of confinement consistent with the primary factors of protection of the public, gravity of the offense, as well as the character of the defendant. Both parties did indicate that probation should be the disposition unless confinement is needed to protect the public from further criminal activity. The defendant needs correctional treatment, which can most effectively be provided if confined, or if probation would unduly appreciate the seriousness of the offense. There were some mentioned during the trial of voters' safety courses. Certainly, new voters do need to know that failing to stop after an accident will result in jail time. All of the factors considered, the court will impose the following sentence. It will withhold sentencing, placing Mr. Lindman on probation for a period of 3 years. There will be conditional jail time of 5 months. Uber, Good Time, and GPS will all be authorized during the conditional jail time. The conditional jail time will start immediately and the bond will be revoked. We will schedule restitution at a later date. Additional conditions of probation will be counseling as deemed appropriate by the probation agent. There will be an AODA assessment and treatment as indicated by the assessment. Also absolute sobriety, as well as community service of 50 hours per year for each year of probation. And that will be 1 hour for each passenger and crew on the loose vessel, as well as on your own boat, Mr. Lindman. An additional condition of probation will be no operation of a motorboat during the period of probation. Because of this conviction, it is now unlawful for you to possess a firearm, and doing so will subject you to civil and criminal penalties. Also, it is unlawful to vote until your civil rights are restored, and you must submit a DNA sample and pay all court costs associated with this case. The probation terms will run concurrent as to each sentence. Are there any further clarifications, and does the state stipulate to the 2 days credit that the defense indicated?
We'll stipulate the 2 days credit if revoked.
The 2 days credit will be reflected on the judgment of the conviction. Is there any further clarifications from the defense perspective?
Yes, Your Honor. So the term of probation and the conditional jail, that is the same, the 3 years, everything's the same as the each count concurrent with each other?
It is. Can it run as 3 years on the negligent operation of a boat? That wasn't positive on that one.
You can add a year for each count. Each one of those misdemeanors would have a maximum of 12 months. You can add a total year for the count, so by the time, it'd probably be cleaner if it was 12.
I'm sorry, you could do 3 because there are 5 or more misdemeanors.
You can do a total term of probation. I agree, but I don't know as to each count, if you could say for this count more than 1 year, you could do more than 3 years of probation.
I think you could say legally 3 years probation for each one.
Okay.
So it'll be 3 years concurrent on each count. Is there any further clarification?
There is, Your Honor. Your Honor, we'd ask that if we could have, first, if we could stay the jail time pending appeal. In this matter, the stay that would be allowed under 969.01 sub 2 sub B. Can provide more information as to what possible parallel issues the court, if the court wants clarification as to that. But first, we'd ask for a total stay of the conditional jail time pending appeal.
The request is not the conditional jail time will be started immediately.
And then the court stated that he's authorized Huber electronic monitoring good time for the conditional time.
That's correct.
Okay. Thank you.
Anything further?
I have a quick question, Your Honor. Did Mr. Simmons finish?
Yeah.
Did Your Honor order a DNA sample and court costs?
Yes, it is.
Okay, good. And as to good time, I think it is my recollection that that is statutorily required when there is a mandatory minimum jail sentence, but there isn't in this case, so I don't think good time is necessarily part of this, but I don't have a citation for that.
That's not necessarily statutorily mandated, but I will authorize it during the conditional jail time. further clarifications?
No, thank you.
We are concluded on that. Thank you.